This is a video about loss of use damages for owners of commercial and personal vehicles. Most people don't fully understand how they can recover loss of use damages, and it's an important element of any cause of action following a car accident or any vehicular accident. I hope you find this information helpful. If your vehicle is disabled in an accident, you are entitled to recover loss of use damages, and this applies to all vehicles, from economy cars to exotic cars, recreational vehicles, motorcycles, and commercial service vehicles. The authority for loss of use damages is a 1968 decision out of the 2nd District Court of Appeals called Meekin v. Dreyer, which is referenced in the Florida Standard Jury Instructions in Civil Cases in the section regarding personal injury and property damage. That case held that if you own a vehicle that was disabled in an accident, you are entitled to collect loss of use damages even if your vehicle is a family car or a pleasure car. And you can still recover damages for loss of use if you do not rent a substitute vehicle. What that means to you is that this case law can be an important part of your strategy to maximize your recovery, including loss of use damages in the event that you are in an accident. Damages for loss of use are paid from the property damage liability insurance of the at-fault driver. How do you calculate loss of use damages? The way to calculate loss of use damages is different if the vehicle is a personal vehicle or a commercial service vehicle. For personal vehicles, the best way to calculate loss of use damages is a simple calculation of rate versus time. The period of time is the period that your vehicle is out of service while it's being repaired, or if your vehicle is a total loss, the period of time is the date of accident until you receive the check for the total loss. The rate is the fair rental value for your vehicle or a similar vehicle. And as everybody knows, all vehicles can be rented and the rental rates are widely published. So this data is readily available to anybody. Keep in mind that cars that are rented are known by classes. For instance, you can rent a small, medium, large, or luxury SUV or a sports car. So when you are investigating the fair rental rate of your vehicle, you need to make sure that you find a vehicle that is either identical to yours or in the same class and find out what is the reasonable rental rate for that particular car. For instance, if your car is a sports car, an ordinary sedan is not a fair substitute vehicle if your vehicle is disabled in an accident. This leads to an important point. Let's say an insurance company tells you that the very most that it's going to pay on any loss of use claim is $25 per day. The internal policy of an insurance company is not the law. And you may have a situation where $25 a day is not enough to provide you with an adequate substitute vehicle. The insurance company is still obligated to pay you your full loss of use damages. So you might make a decision that you don't want to rent a vehicle at all. And instead, what you can do is you can recover the full value of your loss of use damages from that insurance company as part of your overall claim. In Orlando currently, you can rent a Harley-Davidson Softail Classic for $140 per day. Let's say that your motorcycle was out of service for 20 days. The way that you would calculate your total loss of use damages would be a simple calculation. $140 times 20 days equals $2,800, which would be your total loss of use damages. You should make a decision. Do you want to rent a vehicle during this period of loss of use, or do you want to maximize your claim and collect your full damages for loss of use? The Meakin case that I previously mentioned said that loss of use damages is not rental value. However, rental value is indicative of loss of use damages. But then in 1986, the 5th District Court of Appeals, in a case called Maryland Casualty Company versus Florida Produce Distributors, held that the best evidence of loss of use of personal property is the fair rental value of that personal property. Based on these two cases, judges that I have appeared before in diminished value and loss of use cases have agreed to give the jury special jury instructions that say essentially that the best evidence of loss of use damages is the fair rental value of the particular subject vehicle. And that evidence can be very compelling in a trial. But what about commercial service vehicles, like the vehicles that you see on the road all the time? Pest control vehicles, food trucks, vans for cleaning carpet. What happens if one of those vehicles is disabled in an accident? Well, what happens is that the income that was generated from that particular vehicle is not going to be generated anymore. That business now has economic damages, and another way of characterizing that is loss of use damages. Unlike personal vehicles, commercial service vehicles are usually highly specialized. If they're in an accident and disabled, they cannot be replaced. For small businesses that operate with only a single service vehicle, like a food truck, if their vehicle is out of commission, they're not going to generate any more revenue. And this can be devastating to a small business owner. Damages to businesses for loss of use should be based on loss of net income attributable to that particular vehicle that was disabled in an accident. So having good bookkeeping records would be very important in proving up or quantifying the damages that that business suffers. Some commercial service vehicles can be rented, and therefore rental values is another way to try to quantify loss of use damages for a service vehicle. I hope this short video about loss of use damages has been helpful to individuals and businesses. If you think you have a claim, please call me. I'd be glad to try to help you.